you're going to talk to other counsel who've used them. Every law firm has the email system, which goes, through his look. Judge X has been proposed as a mediator in this case. Anybody know anything? You'll get 15 emails in the U.S. from people who say, yes, the person's good, no, the person's terrible.
Oh, sure.
And if you haven't used them before, that's how you're going to find out. Normally, their reputation on the bench precedes them. We have had some very successful mediators who were rude and abrasive people. And we inherited them. They were very successful. And I would get calls from lawyers telling me that this person was rude to them. And I said, well, do you live in a box someplace? Yes, he's rude. Did your case settle? Well, yes, it settled. He made me settle. I said, how could he make you settle? You can get up and walk away.
It's like going to eat at a restaurant in New York. You pay to be mistreated.
But that was years ago. Now that's not tolerated by the marketplace because you have people who are so experienced. The mediation business is very different now than it was in '95. In 1995, the mediators knew more about mediation than the lawyers did. That's not true today. The lawyers who use mediation on a day-to-day basis in the United States know a lot about what the mediator is going to do, what the mediator knows, what their moves are. It's like the old joke of telling a joke in prison. They've told it so much they give it numbers. Guy gets up and says number 23. Everybody laughs except one guy, and they say, "Why aren't you laughing?" He says, "Well, I think Joe tells it better than him." So the mediator has to stay fresh. He can't use tired, any mediator that gets up in the United States today and starts talking about the cost of defense and, what's it going to be and everything, those are old, tired things. You've got to get past that kind of mediation technique fairly quickly.
Well, let me put things in a perspective of a non-U.S. company,
yes,
that's maybe doing selling in the United States, contracting with the U.S., yes, and whether to include mediation in the contract.
Yes.
Isn't that part of the pitch right up front, though, to say the costs and the stuff, the idiosyncrasies of the U.S. system are such that you almost, as a foreign company, cannot afford not to put a mediation clause into any significant contracts in the U.S. And you've got things that you have in the U.S. that you don't have other places, or civil juries in civil cases, the lack of fee shifting to the losing party, contingency fees, an extremely expensive disclosure or discovery practice that you really don't encounter, or you encounter it much less outside the U.S. And certainly, for civil law countries or parties located in civil law countries, these impose incredible costs. Can you justify, I guess, not putting
The issue of the cost of litigation in the United States for a foreign company that's not used to that kind of system is just enormous, and foreign companies are not used to it. So, yes, I believe that mediation is going to save them a lot of money. But the big thing is that they're going to be able to achieve a result that they're in control of. And the second basic item is that they're going to be able to achieve something that they can't get in arbitration or in a court. Those two things, the control and the ability to fashion a settlement that is going to go beyond what they could get in arbitration or in court, would be enough for me to say, let's give it a try.
Right. But I guess my point is just one that having access to a dispute, alternative like this could make buying and selling into the U.S. or with U.S. parties a lot more efficient, really, yes, a lot more effective. What about jams and you guys internationally, outside of this vast U.S. experience that you have? What are you doing on the international? We're in Rome, so you must be doing something. Although it's not a bad place to come.
It's not a bad place to come, and it's one where if you like car horns. It's the place. It is absolutely the place to come. We decided that the role for us in Europe was to form an alliance, which we did, called MEDAL, with the ADR Center in Rome, CMAP in France, a group in Holland, and then CEDAR in London. We started with an alliance with CEDAR, and then expanded it to include the major groups in each country. We already do a lot of international arbitration. We have international rules. More and more U.S. companies are adopting JAM's international arbitration rules because they are more friendly to the lawyers. They are not front-end loaded with costs. You know, arbitration at JAMS, you don't write a big check to get in the door. So it's a pay-as-you-go system.
No advance on fees.
No advance. It's $500 or something like that to file an arbitration at JAMS. And that's because we feel that parties should have the ability to settle and not have an investment in fees, right. Nor do we have fees that are dependent upon the amount in controversy. Right. You know.
Well, I personally, I've had a lot of people say the advance on fees is advantageous because you know what the costs are going to be at the outset, and that is actually a useful tool to be able to say this is what, at least leaving aside the legal fees, you know what the cost of the arbitrators and the institution will be, and it's this amount because it's based on the amount in dispute. But in practice, what we found is it does in fact create something of an investment in the dispute because you've paid it. Yeah. Although people don't realize it, but this is, I should say this at least to the benefit or to the credit of some of the institutions that do have these advances. My experience has been that if you settle early, but you have to settle very early after having paid the advance, you can get back, not all of it, but a big portion of it. So, anyway,
you have to settle very early.
But you have to settle. Well, the earlier you settle, the better chance you have of getting some or all back.
So we do. Our people sit on ICC panels, on AAA panels. I mean, we do AAA arbitrations every day. So again, we manage the practices of what we think are the best neutrals in the country. But we also realized that the state of ADR in Europe was that we were probably not going to be selected unless there was an American-based company involved some way. And so for us to open an office here in Europe with the level of ADR being what it is was not what we think we should be doing. I want to open in South Florida before I open in France. I mean, I'd like to spend more time in Paris, but I think I've got to. There are other parts of the country that we have to penetrate.
We do a lot of business in Rio.
That's it, and come up through Miami.
Quickly, class mediations.
We are doing more and more class mediations, and I can't remember when there has been a class action case tried. I mean, really, we did the Enron. We did all of the Enron class action securities. We do huge numbers of securities cases, mass tort drug cases. We're doing Zyprexa. We did Fen-Phen. We did Resolent. So wherever there is a bad drug, multiple injury case, we end up not only settling but also handling the allocation. What has happened in the U.S. is when you have plaintiff lawyers representing large numbers of injured parties, when they try to allocate the fund themselves, they ended up getting sued because there was obviously a conflict of interest, because there wasn't